Hello everyone. In today's RECONNECT webinar, we will discuss the newly published edited volume with Cambridge University Press entitled EU Law in Populist Times, Crises and Prospects. I'm Alexandra Nemoylen from the Leuven Centre for Global Governance Studies at KU Leuven, and I will be your moderator today. This volume looks to shed light into how EU law has become increasingly salient during the crisis of the past decade in areas such as economic policy, migration, internal security, and democratic backsliding. These areas are all related to key domains of state sovereignty, but of course at the same time, they're also EU policy areas that occupy center stage in all the debates that have emerged between the European establishment and populist parties, precisely because of the economic and social and indeed constitutional issues involved in reaching into core state functions. So our distinguished panel will begin with cross-cutting lessons from the EU's governance of these policy areas with the editor of the volume, Professor Francesca Bignami from George Washington University Law School. This will be followed with key conclusions on internal security and data protection with Professor Valsamis Mitsilegas from Queen Mary University of London. And finally, we will have some final reflections on economic governance from Professor Renaud Dehousse, President of the European University Institute. And with us to provide some feedback and comments is Professor Michelle Egan from the School of International Service at American University. So thank you so much for joining us today. As always, we very much look forward to your questions, which you can send to me via the webinar chat box, which you can find in the control panel. It's my pleasure now to give the floor to our first speaker, Professor Francesca Bignami. You have the floor.
Thank you very much, and thank you for that kind introduction. Thank you also to RECONNECT for hosting this book panel on EU law in populist times. It's a real pleasure to be part of your series. EU law in populist times tackles the areas of EU law that have been become increasingly popular since 2009, since the Euro crisis, since the refugee crisis, since the terrorist attacks in Paris and elsewhere, since the rule of law backsliding. The book is organized in 4 parts, each of which maps onto the law that has emerged in response to the crises. And you'll see on this slide a rough table of contents. The book has 4 parts, one for economic policy, one for human migration, one for internal security, and one for constitutional fundamentals, which I define as the rule of law policies that are designed to combat democratic backsliding. Now, I've slotted in the contributions that we will be focusing on today. And I'm very grateful that 2 of the authors were available for today's panel. Each part of the volume includes chapters by leading scholars and policymakers in their respective fields and gives the essential background on the law as well as the state of the art on the normative debates and the theoretical debates. The 2 chapters that from the bulk of the book that will be presented today are the chapters by Professor Dehousse on the economic policy that has developed since the Euro crisis and the impact on EU democracy, and the chapter by Valsamis Mitsilegas on internal security and the data protection, due process, and other kinds of rule of law issues that have arisen in that field. I've written the introduction and the conclusion to the volume, and that the conclusion is what I'm going to be focusing on today, the cross-cutting lessons that I draw from the many different experiences that are included in the volume. Now, the book is designed to reach two related audiences. First, advanced students who are being introduced to the new areas of EU law, and second, researchers who are specialized in one subfield and want to get up to speed quickly with the law and the theoretical debates in other subfields. Now, before going any further, I would like to talk about the reasons for the book. Why take on such a broad and wide swath of EU law, areas which the discipline generally treats as discrete subfields? And there's an anecdotal answer and there's a more theoretical answer. First, the anecdote, which comes from my personal experience. So before I went to law school, I was exposed to EU law because I did a stage at the European Commission for the Americans who are listening in, stage and internship. It was fall of 1992. And on the first day, the hundreds of stagiaires in Brussels were gathered to hear a speech by a prominent civil servant from the Directorate General for Internal Market. Now, since it was a run-up to December 31st, 1992, the single European acts deadline for the completion of the internal market, her talk focused on harmonization directives. And the example she gave was the color of car headlights. And I hope you can tell from there that there's a car there with yellow headlights. Now, in France, the headlights were yellow, but in the other member states, they were white. And the harmonization directive that was passed required white headlights of all EU cars. And so the car you see there was harmonized out of existence. The directive was considered a significant achievement for the internal market because it improved the regulatory conditions for a robust internal market. And later on, when I got into teaching the introductory course in EU law, the internal market and its policy output, including things like headlights, could serve as the principal example of what the EU actually does. But since 2009, that has changed radically. And the EU is in the headlines a lot more, but it's not the internal market EU. It's the Greek bailout, it's the lines of Syrian refugees, it's the democratic backsliding in Hungary and Poland. And I use the slide here from the infamous slide from the Brexit campaign as a stand-in for all the highly politicized and contentious issues and law that the EU now is in charge of, or at least involved in. So now let me give the more theoretical answer to the question, why the volume, and why take on all these new areas of law. And I argue that they share two very important characteristics. First, they are areas of EU law that reach into core state sovereignty, economic into fiscal spending, migration into territorial belonging, internal security into physical safety, and constitutional fundamentals into the organization of politics and society. The choices being made are much deeper than the choices made in the internal market context of car headlights. And that's why in the introduction and the conclusion to the volume, I call these areas of law sovereignty sensitive law. Now, the shared second characteristic is related, and it's that these areas of law are very contentious. They are at the heart of today's heated political debates between establishment political parties and mainstream and populist forces. The left, especially in the South, wants less austerity, more spending. Right-wing politicians like Salvini push back against asylum law and want tougher border control. Autocrats like Orban make a point of demonizing and denigrating key aspects of liberal democracy and undermining the jurisprudence of the Strasbourg and Luxembourg courts. These are very tough areas of law for the EU to navigate, but it is essential for its long-term survival and success that it do so. And the COVID crisis, which hit roughly at the same time as the volume came out, has dramatically underscored the importance of the EU law covered in the book. Now let me turn to my conclusion. And what I'd like to first point out here that I'm going to be bracketing the constitutional fundamentals part of the book. There are a couple of reasons for doing so, but for present company, the main one is that RECONNECT has already hosted an amazing set of webinars on democratic backsliding and rule of law by many of the authors who are actually in the book. I really encourage people to read the wonderful chapters in the constitutional fundamentals part of the book. Okay, then conclusion. In the conclusion, I argue that the common characteristics of sovereignty-sensitive EU law give rise to problems for what legal scholars care about, the legitimacy of EU law, what law should be in a liberal democratic order. The legitimacy framework that I use is drawn from widely accepted theories of law. It's very standard. Law should be knowable to legal professionals and citizens, meaning it should be accessible and it should be understandable. Law should respect fundamental rights, and it should be generated through democratic processes. Now, on knowability, the common characteristic is that sovereignty-sensitive law has arisen through spillover. That is, because it reaches into core areas of sovereignty, member states have been reluctant to transfer power, and they've done so slowly and piecemeal. And this in turn has generated a lot of legal complexity, which is a problem for the knowability of law. The argument is somewhat technical, but the fundamental point is that there are two related sources of complexity. The first is variation in the legal instruments available for cooperation among the member states, some of which is international and less binding, some of which is supranational and more binding. And in this slide, I give an example from economic policy, where there are regulations and directives to deal with the European semester, which are classic TFEU instruments, and they're supranational law, but there are also MOUs signed by the ESM and bailout countries, which are international law in nature. Now, the second source of legal complexity is change over time, as either treaty reform or the jurisprudence of the Court of Justice ratchets up cooperation and moves these norms from the international to the supranational. And in the PowerPoint, I illustrate the moving target quality of EU law with human migration and internal security, which were transferred at different points in time from the International Schengen Convention to the TEU to the TFEU. And the solution to this problem is more legal simplification. There's already been a lot of legal simplification in the EU, but in the conclusion, I point to several remaining possibilities. One of the most obvious is the ESM, the European Stability Mechanism, which is based in the international treaty, was the main mechanism for bailout loans, and now includes the roughly 240 billion euro pandemic crisis support line. There's a good argument for moving that from the treaty into the TFEU treaty with a special status similar to the ECB. Turning to fundamental rights. So the common characteristic of the new EU law is that the new EU law burdens classic rights. It burdens liberty rights from the 19th century, and social rights, which date to the post-World War II era. And therefore, what's very clear is the EU no longer regulates just markets, but it and burdens the rights of economic operators. It burdens other kinds of rights too, which means that it's especially important for EU citizens to get access to justice to litigate their rights claims. The problem, however, is that there's evidence from the new policy areas that it's actually been especially difficult to litigate. And here for economic policy, I rely on the work of Claire Kilpatrick, who has documented this in the context of social rights challenges to bailout conditionality. And I think something similar is going on for the many EU databases that have been created in internal security and human migration, the main example being the Schengen Information System. These raise privacy and due process concerns, but so far, many EU regulations have not been squarely tested in the CJEU. The reason for this lack of fundamental rights challenges is to EU law, is the EU's longstanding system of jurisdiction and access to justice. Individuals generally cannot bring direct actions through 263. They have to go through 267 and the preliminary reference system, which contains many different hurdles. And this limited standing for direct actions in before the CJEU has been criticized for many, many decades, and it's stayed the same for many, many decades. There have been relatively few changes to the system of standing. And in my conclusion, I argue that actually it might be time to rethink this issue because of the different circumstances now of EU law. The EU law does burden the liberty and social rights, which are really foundational to any liberal democracy. So, so that's the argument on rights. Now, the last issue is democracy. And I analyzed the new EU law based on democracy. Now, my definition of democracy is very straightforward. It's the Lisbon Treaty template of ordinary legislative procedure for the Parliament and the Council to enact law, and accountability to the Parliament and Council for administration. The common characteristic that's relevant for the democracy analysis is that the sovereignty-sensitive areas of law covered in the volume, the new EU law, is very, very contentious. And it's very salient to national publics. And when there is contention, the European Parliament tends to be locked out, as the different chapters in the volume show. The EU institutions that move forward with integration are either the member states in various intergovernmental settings or bureaucratic actors. So there's either big power politics among the member states or delegation to administrative actors. And the volume contains many examples of this dynamic. Professor Dehousse's chapter illustrates the institutional dynamic in the bailout context. Lilian Sordi writes in her chapter on asylum law and the refugee crisis that legislative negotiations in the Parliament, with the Parliament, on reform of the asylum system have broken down. The system features the notorious Dublin rule that assigns responsibility for asylum seekers to the first Schengen state of irregular entry. And it's been impossible to change that rule, even though it's very problematic because of opposition from certain member states. So where progress has been made is not through legislation, but through administration and cooperation among member states, member state bureaucracies through the EU Asylum Agency on processing and relocating asylum seekers, and also through the EU Agency on Border Control and the Coast Guard. So this sidelining of the European Parliament is a problem for supranational democracy, but as a matter of political fact, there's not much to do about it. However, I argue in the conclusion that there should be a greater transparency to the European Parliament. It should be possible for EU agencies and the Commission to communicate more about the specifics of their policy and economic policy, immigration, internal security, and this should at least lead to more debate in the European Parliament, and then ultimately, hopefully, to greater solidarity and democracy on a supranational, transnational level. With my last couple of minutes, I would like to conclude with some observations on what the book has to say about the EU's response to the current crisis, COVID-19. Now, the scale of the crisis is enormous. The EU has come into under a lot of criticism for its handling of the crisis. As things stand now, however, I think that there's some grounds for cautious optimism. That is because there's rupture with some of the law in the book that's problematic, and this continuity with some of the law of the book that's promising. So first, the economic crisis and the EU's response. The Commission has proposed a 750 billion euro coronavirus rescue package on top of the other funding that has already been committed. And this proposal represents a rupture with the bailout era economic law covered in the book. And that is because there will be limited, if any, conditionality. And a lot of the funding will come in the form of outright grants, not loans. Moreover, the legal framework will be in the EU budget. It won't be outside in the ESM, so the funding will be distributed and overseen pursuant to all the standard legal acts, procedures, judicial review. And this is an advance on the substance, since austerity was always problematic, and it's an advance in legal form. So since going back to my discussion of the conclusion, this will not introduce additional legal complexity. It will be squarely through well-established procedures under the TFEU. Turning to the health crisis and the EU's response, as is well known, the EU doesn't have significant legislative powers for public health. It's called a so-called supporting competence under Article 6 TFEU. And so the Commission's response has been by necessity administrative. What the Commission is doing is using its minimal powers and access to funding to coordinate member state health bureaucracies, to assist with the purchase of medical equipment and the development of a vaccine, and hopefully very soon the rollout of a vaccine. This low-profile coordination of administrative actors at the national level represents real continuity of what the EU does in other areas with internal security and human migration. And earlier here in this presentation, I gave the example of the EU Asylum Agency, but there are many other examples in the book of this low-level administrative coordination. This administrative approach has been relatively effective in other policy areas. And so there's some reason to think that the Commission's limited tools can make a difference in the COVID context. And so with that, I'll conclude, and I very much look forward to our discussion.
Thank you so much, Professor Bignami, for this initial overview that I think already gives us a good sense of how a key driver of contestation is this mismatch between the capacity of the EU legal system and the expansion of the EU in terms of its competences, alongside, of course, other issues such as transparency and accountability. So thank you so much for that. And now we move on to Professor Mitsilegas, who will instead focus on another key area, especially in the context of the current crisis, which is internal security and data protection. You have the floor, Professor Mitsilegas.
Thank you very much. First of all, I want to say a big thank you to Francesca for including me in this project, in the wonderful conference in DC, and of course in today's event, and many thanks of course to the colleagues in Leuven. It's always a pleasure to interact and to work together. So my intervention will focus on security, and what I want to do is in the first part to reflect on many of the remarks that Francesca has already provided about the role of sovereignty and, if you like, populism, the evolution of EU law and policy in the field of security, and secondly to discuss how many of these challenges, the challenges are not only fundamental rights challenges, but also rule of law challenges, are amplified, if you like, in the current COVID-19 era, because I think that many of the debates that we have had over the past 10, 20 years come back with a vengeance in the context of the COVID management, if you like. So first of all, I think what connects also the work, the different chapters and parts in this book, is really how does a polity respond to perceived or real crisis. So I think that part of our conversation on the impact and the form of EU intervention is linked to the fact of how do we respond to events which are framed largely by politicians as being existential threats. And the field of security, I think, has always been a key example of that. And you see it also in the work of international relations scholars, especially the Copenhagen School of the whole securitization process, where you have phenomena being developed and framed as security threats. And I think in terms of the pace, if you like, of European integration and whether we have more or less Europe, what has been quite interesting is that in the beginning, the European Union has used crises as opportunities in these sovereignty-sensitive areas. It obtained competencies timidly, in the three-pillar structure in Maastricht, and slowly these competencies and powers have been communitarized lastly in the Lisbon Treaty. Yet at the same time, as we see in more recent years, and that's the paradox, and I think Francesca highlighted in her remarks, the crisis mentality and the sovereignty sensitivity of these issues have led, in a sense, to a backlash and to some turning back from the supranational way, if you like. So more recently, especially in the field of immigration, we have seen really member states going it alone or going it outside of the EU framework. The EU-Turkey deal is a characteristic example of this, a deal that the Court of Justice really declined to include within the EU framework. And if one follows the litigation of the Court of Justice now in the field of migration, in sensitive issues such as the relocation of migrants, such as access to the territory, you see a battle between exclusion, from EU territory or from national territory, and really the applicability of the EU principles. So there is a slight paradox here, because on the one hand, the EU has been very successful in expanding its power in the last 20 years and include within its competence areas that, would be unthinkable, perhaps, if you think about it, to have competence in criminal law, to have established a European public prosecutor very recently, to have common policies on immigration, and at the same time, the integration of these areas within EU law lead to challenges to the very foundations of the European Union, of its basic principle, fundamental principles, including the principle of the rule of law. And by rule of law, I'm not going to focus so much on the aspects of judicial independence or rule of law backsliding, but I think there are other aspects as well, and I have categorized it as rule of law ex ante, by which I mean the challenges on how legislation is made. Is it properly scrutinized, or is it passed, if you like, as an emergency measure under a state of emergency? And we have seen quite a lot in the context of counterterrorism here in the EU, where after every single terrorist attack, we have a response by the EU. And interestingly enough, even in the responses in 2016-17, in terms of scrutiny, have not been much better to the responses that we had after 9/11, although now we are in the post-Lisbon era. But we also have the rule of law ex post, which is really, in a nutshell, what Lord Bingham, in a common law tradition, has framed as the protection from state arbitrariness. And here, I think, in how the EU security acquis is being implemented and immigration acquis, we have many, many challenges. What complicates, I think, the picture even further is that in the past 5 to 10 years, we have seen really the blurring of the boundaries between various EU policies and objectives, and most worryingly, in my view, the clear blurring of the boundaries between migration and security. So I think the EU is slowly adopting the American view that it is all about security. To fight security, you really need to have access to everything. We see clearly a clear example, I think, is another chapter, I think, in the book, Francesca, is the uncritical and, after long battles, allowance of access by police authorities to EU immigration databases such as Eurodac, which is the fingerprints of asylum seekers, and the visa information system. So increasingly, and if you read the strategy on the security union, you have really this blurring of boundaries and this really attack on what in data protection law is called the purpose limitation, if you like, but this I think you can apply to, if you like, the logic of it to other areas of law. So there are challenges. I think there are challenges stemming both from states' attempts in the banner of maintaining sovereignty to attack, if you like, fundamental rights and the rule of law at EU level, but also challenges from the fact that states may prefer, if you like, on the one hand, intergovernmental elements of cooperation, and on the other hand, if you like, delegation, as Francesca mentioned, and also emphasis on technical, technological, depoliticized ways of integration. And I think we have seen these challenges very acutely in the current debate on COVID-19. And I think Francesca has taken a more optimistic view than mine on this, because what we have seen in Europe in terms of immediate, if you like, COVID management, you had on the one hand the unilateral closure of borders in a policy which you would argue is an EU policy, so it is not like health, which is really a softer policy. So in terms of management, you suddenly had member states unilaterally closing their borders with very little in terms of coordination. The Commission on the back foot and trying really to gain ground in the past few weeks, but we'll see how this will go. And secondly, you had, of course, an instinctive, if you like, emphasis on digital surveillance, and again, without really a coordinated approach. So, and I think that I will focus on the digital surveillance as COVID management technique, if you like, to focus really on three challenges that we face currently in the interplay between security and the rule of law, which are, I think, symptomatic of broader, if you like, debate in the field of internal security law more generally. So first of all, I think what really has changed the game in the recent years has been the digital. So, the fact that any response on security and including on COVID is based on digital data. So, the digital is central to everyday life. Increasingly, any form of management, security management, population management is taking place on the basis of digital data. This is really, of course, very, very sensitive for privacy, data protection, but also, in my view, and in the view of the Court of Justice, on broader issues of freedom of expression and of democracy, in a sense. What is the position of a citizen? What is the relation between the citizen and the state when the citizen is under generalized surveillance, in a sense? So I think the current emphasis on the digital in managing COVID-19 brings about these tensions, I think, very prominently. The second, I think, challenge comes from increased privatization, if you like, of life, which is linked to the digitalization. So, we have the public-private partnership or relationship, which increasingly is a common feature of security responses. So, especially in the field of retention of data, transfer of data, recent proposals for removal of terrorist content online. The private sector is really being co-opted by the state, to be a security actor. But I think in COVID-19, what we have is really, if you like, the dominance, if you like, of the private sector. I think recently in the UK, for those of you who are following the saga of the UK responses to COVID-19, you will know that the UK government has abandoned plans for a centralized NHS-based digital tracking system in favor of the so-called decentralized Google Apple COVID tracking app. And I think there you see how this has really been implemented in different countries with different models. Some people call it here the triumph of the private sector over the state. I mean, you could argue there is a confluence because this might be more privacy friendly as well. But, I think in terms of the relation between the public and the private and the power between the relation between the public and the private, I think that's something very interesting. The third challenge, I think, is that we increasingly will see a belief by policymakers on the infallibility of technology. I think we see it also partly in universities, the belief that blended learning, digital learning will be all the rage in the current era and that our students will be very happy if we do everything online. But I think in the field of security, this has been really on the agenda for a long time. the key buzzword, I think, in Commission officials in the field of security is the term interoperability of systems, which I understand comes from computer science, and which the Commission floated for the first time, I think, in the Hague program in 2004, but finally, 15 years later, it managed to legislate on it. So it managed to legislate on measures calling for the interoperability of immigration databases. And this is a solution that is desensitized, depoliticized, and with the Commission claiming that it doesn't really create any further human rights concerns because it doesn't involve processing. So, you know, as long as we link the databases, technically, we are okay. We don't need any further scrutiny. And in my view, this raises very significant rule of law implications. Now, on COVID-19, what is very interesting is that the Commission has published a recommendation on interoperability of national tracking systems. And that's quite interesting because here we do not have EU systems. We have very low competence, as Francesca mentioned. We have systems that are experimental, that you know, and with every single country, huge data protection implications have been raised, and where you know the Commission is saying all this needs to be interoperable in order to achieve free movement. And you know, it makes me wonder how free will movement be if its backbone is really generalized ongoing surveillance of mobility. So, you know, this raises many questions. And really the final question, I think, and I will stop here in my view, is going back to the legitimacy point that Francesca made, is what is the impact not only on fundamental rights? I mean, the impact is obvious, I think, on fundamental rights, but there is the broader question of polity, of the relationship between the citizen and the state, and how is this transformed, you know, in this new landscape? Because one of the key issues, I think, for any of this to work, and we see it with COVID very, very clearly, is trust. You know, these measures will not work if there is no trust by the citizen to the state. There is very low intake, for example, there is very low uptake of apps throughout Europe so far. And these measures should not erode also the trust from the state to the citizen, and also from the fact that the citizens should feel that they have a space of liberty and they are not really under a state of constant surveillance. This is not just an academic, myself as an academic saying this, and it sounds quite Orwellian, but it is also, you can find these statements in judgments of national constitutional courts, the German one and the post-communist ones, and the Court of Justice in the litigation on data retention and on mass generalized surveillance. So, you know, courts have been saying that the citizen should not be feeling under a permanent sense of being watched. So watch this space. Technology may solve problems, but may also create further challenges. And I stop here.
Professor Mitsilegas, thank you so much for bringing into the discussion so many other very interesting issues, and I would say more broadly kind of the vulnerability of human rights, the rule of law, and indeed legitimacy in the context of emergency policy making, and all issues I think we'll go back to in the discussion. And now it's my pleasure to give the floor to Professor Renaud Dehousse, who will delve into another area of policymaking, which is probably the most contested, which is economic governance. Professor Dehousse, you have the floor.
Thank you very much, and thanks in particular to the Leuven Center for Global Governance Studies for hosting this debate. It's, I think, an appropriate moment to discuss the issues we are tackling today, since we've just celebrated a few days ago, if I'm not mistaken, the 4th anniversary of the Brexit referendum, which was, of course, one of the hallmarks of the previous decade, which certainly marked a high point in, let's say, citizens' I was about to say rebellion, at least demonstration of discontent vis-a-vis the overall evolution of the European project. So we have to ask ourselves why this is so, why as integration has progressed, it has elicited more and more reactions, more and more hostile reactions, and where this may possibly lead us. I will therefore put my footsteps my feet in the footsteps of my colleagues and just echo some of the issues that they have mentioned. I will by necessity be, let's say, a bit schematic because we don't have too much time, but hopefully it will enable us to discuss these questions in the second part of this session. I have essentially 4 points I want to make. The first one is linked to, let's say, where we come from. The classical model of integration, and in particular of integration through law, if you allow me to echo the title of a well-known series that was published by a group of scholars coordinated at the European University Institute 30+ years ago. And it's really important to understand the, let's say, the basics of that model, because I think that this is what is increasingly a challenge nowadays. Integration through law is at times told as a, let's say, as a glorious story in some corners of enlightened leadership by people who wanted at all costs to avoid the mistakes of the past. And I don't want to dispute that there was much of that. I simply want to suggest that we will not understand, we cannot understand how this project has developed and the problems it is now running into if we limit ourselves to this heroic narrative of the first decades of European integration, as, for instance, a great British historian, Alan Millward, has emphasized. If you want to understand European integration, you must also include in your analysis the fact that, yes, it was largely conducted by states and governments, but the leaders of those states at the time were not only inspired by high ideals, but also by considerations of national interest in the first place. And secondly, by a fairly, let's say, persistent mistrust in each other, which I think is a foundational element in the European construction. Why do did we have in the first place a system that placed so much emphasis on supranational bodies as acting not only as a source of initiatives, but as an instrument of control over what the states do? Well, simply because it was felt that each country felt that its neighbors had also to be controlled, and that if left to operate freely, they would develop policies which would not be in everyone's interest and which would be detrimental to the national interests of all participants. That explains why the system was initially designed with a strong high authority in the Call and Seal community and a strong commission with a lot of surveillance powers in the first place, why the system was endowed with a strong judiciary, which was given a monopoly of adjudication over interstate disputes, but also developed a very extensive jurisdiction over anything that pertained to the integration process. This resulted in an integration process which was largely negative, in the sense that it consisted of negative rules telling states and subsequently people what they should not do, with a strong surveillance mechanism in which independent bodies played a central role. Now, you might say this is yesterday's Europe, but I don't think so. And here, let me speak a minute of the issues that I discussed at greater length in the book. If you look at the EU's reaction to the economic and financial crisis that started in 2007, 2008, you will see that it did rely a lot on more control powers being granted to the EU. And on top of that, to independent bodies within the European institutional system. I mean, if you look at who gained power as a result of that crisis, you will see that, of course, there is one institution that emerged quite strongly, which is the European Central Bank. Whatever its take from Mario Draghi was an assertion of authority, and the assertion by the ECB that basically it could be the lend of last resort that nobody thought at the time of the Maastricht Treaty it would become. But there is also in the same package, to a degree that was perhaps less noticed in the beginning, the conferral of more, again, control powers to the European Commission, for instance, by the fiscal compact. Why did that last development take place? Because people suddenly fell in love with the European Commission? Certainly not. But there I refer to what I said earlier. One of the prime motivations of key actors in European integration is horizontal mistrust. The Germans did not fall in love with the Commission, but they wanted somebody to control Greeks, Italians, Spaniards, possibly also French, and they felt that this was the Commission's task. And of course, the others could only agree to that because they preferred to be controlled by the Commission than being controlled directly by Northern European countries, which gave on that occasion some indication of their unwillingness to accept fiscal policies which they found too lax. So my point is that negative integration in the development of supranational authority is not a thing of the past only. It's also, let's say, a structural feature in the integration process, which I think we see at work even in our days. I mean, look at the discussion on the, in the country in which I live, Italy, people started by calling Corona bonds. What was the idea? To have bonds issued by Europe that would guarantee expenditures done by national governments. But there was little chance that Northern European countries would be willing to subscribe to a system in which they would have to guarantee the debt of other member countries. What are we discussing now? A system in which, instead of guaranteeing the other countries, the other guys' potential debts, we may be, with the recovery fund, heading towards a Europeanization of the assistance process that will see the Commission take the responsibility of issuing bonds on the one hand and granting relief in ways that remain to be determined to the other countries. So you see, it's again the Commission called upon to play a central role because the member states do not trust one another. So definitely not a feature of the past. Now, what has this to do with populism, which is another systemic development of our time? Well, the problem here, I would say, is that while we have witnessed in the last decade a fair degree of Europeanization of very sensitive policies, as outlined by Francesca in her introduction, we have in parallel witnessed the emergence of populist forces, populist anti-European forces in, I think, virtually all the EU member countries. I mean, there was a time where it was felt that some countries were important exceptions to the trend. It's no longer true. I mean, name one country in which there is not a populist party that challenges membership in the EU. And clearly, the idea that somehow elite-based governance and rules-based governance, which is one of the hallmarks of the European model, was basically incompatible with democracy. Hence the big slogan of the Brexit campaign: take back control. People need to take back the control of their destinies, and so the populist movements say this implies at least taking away power from Brussels, if not walking out completely from the EU. Now, I don't dwell on the emergence of populist movements because I think this is well known. What is perhaps less noticed is that this is not simply a national problem that has a strong impact over domestic politics. It is really a European problem that has a strong impact over EU politics as well. How? Well, in several ways. First, indeed, Europe has become European integration, and European issues broadly defined have become a central feature in domestic election campaigns. And this has led to a process which is perhaps less salient than the emergence of populist forces, but at least as important for EU politics, namely a certain degree of hardening of the European stance of national governments. Look at the situation in the Netherlands, for instance. The Netherlands is a country that used to be looked at as like the other Benelux countries as one of the heralds of integration. Whenever there was a discussion on the reform of the EU, there was a Benelux paper in the Netherlands was happy to sign strong pro-European manifestos. This is no longer the case. No government in its right mind in the Netherlands will sign this kind of manifesto in the future. Not because they've all become populist. This is not what I'm saying. I'm taking this as an illustration of the fact that the emergence of strong populist movements, which has taken place inter alia in the Netherlands, it's just an example I'm using, has had an impact over mainstream political forces. And in all countries, you notice the same phenomenon. That is to say, people from political forces which used to be pro-European or at least benevolent neutrals, now are fairly outspoken critiques of the way the integration process unfolds. Mark Rutte is one example, but I could have named Matteo Renzi from Italy, who really made part of his early political fortune on a very staunch critique of the way European policy was conducted, or if you turn to Germany, Annegret Kramp-Karrenbauer, when she was leading the CDU, was also extremely vocal in her critique of the Brussels way, so to say. So that's the point I'm making, which is, in thinking about European politics, Salvini and Le Pen are perhaps not the most central elements, but they have a very strong impact over the behavior of, let's say, mainstream parties in power, which then, second point, results in decision-making process at European level, which is more and more difficult, because simply say a consensus-based system needs the formation of large majorities. The more polarized the system gets, the more difficult it is to get those majorities. And it's true that we now have in Europe a big north-south cleavage, to which I already referred, and that was quite visible in the handling of the previous crisis, to which you also have an east-west cleavage, which is equally pervasive and which made it difficult to address, for instance, the migration challenge. So polarization makes it difficult to achieve consensus, and because there is no consensus, the EU often finds it difficult to get its work done, which is why after the Big Bang of 2012, for instance, in banking union, the EU wasn't able to complete really the harmonization, the banking union, as it is called in the EU jargon, that is to say, the harmonization of banking regulation. That is required for a proper European banking market, or the fact that even though Chancellor Merkel declared the Dublin asylum system dead in 2015, we still don't have a successor because of the impossibility to agree on a reform of any kind. So what I'm saying, in other words, is that the emergence of populist forces has really had a strong impact over the way the European political system operates, and over the ability of the EU to deliver a certain number of things. Now, how can we square the circle? And here I move not only to my conclusion, but also in a way to Francesca's conclusions. How can we square the circles between a first trend in which we have the development of more control powers at the European level in response to a series of crises, and on the other hand, more and more opposition to the transfer of authority in Brussels and the way this authority is exercised? Francesca has mentioned the necessity to enhance the role of the European Parliament and confer it a political clout that it hasn't had so far. That's certainly one avenue. I would like to suggest that more than this is needed. That is to say, if we are to respond to the claim of those who say that citizens need to take back control, then we must give them the instruments for that kind of control at European level, if we do not want them to be tempted by the idea of repatriation, of bringing those powers back at the national level. Now, how do you achieve that? How do you achieve a system in which basically Europe responds to the expectations of its citizens? We have already something which is not exactly new, namely the European elections. But so far, they have failed to deliver a kind of political chain of control whereby voters would send a powerful message to the rulers, and the rulers would have to listen to what the voters have said for all sorts of reasons, because of the electoral system that is used, because of the fact that there was a fair neglect for European issues at the time of the European elections. It has not happened, and that has led to a well-known phenomenon, namely the decline in turnout at successive European elections until the 2019 elections. How to change that? I would say by giving people a say, by giving people a stake. We witnessed in 2014 a very interesting political innovation, which was the invention of the so-called Spitzenkandidaten system. That is to say, a system in which the main political parties would nominate their candidates for the top job and have those people campaign. The system that I think was virtually enshrined in the EU institutional system since the Maastricht Treaty, but was really orchestrated for the first time in 2014, sorry, with a surprising success. I didn't think it would work, but it did work, not to the benefit of the main promoter of the system, namely Martin Schulz, but to that of Jean-Claude Juncker. But Jean-Claude Juncker, against the will of a number of people in the European Council, even including the will of the most powerful country in Europe, whose chancellor was not at all convinced by the wisdom of the Spitzenkandidaten system, and he made it to the 13th floor of the Commission building in Brussels with a program of its own, which he tried to implement to a large degree. If you look at the Commission's program, the Juncker's Commission program, and the program of Jean-Claude Juncker when he ran for the presidency, you will see that there is a fair bit of convergence. So here we have the rudiments of a political chain of command, where candidates go before voters, put forward a program and try to implement it if they are lucky in the election process. And this, I would argue, is the basis of a system that could make the union more responsive. Responsiveness is really the key concept here. More responsive to the concerns and the needs of its citizens. Now, as you know, the story in 2019 was a bit different, probably because it was the second time and people were warned, and also because, let's say, none of the contenders for the Commission presidency really emerged strongly confirmed by the popular vote. Now, is this the end of the Spitzenkandidaten system? I don't think so. It would even go as far as saying that if you look at what happened to President von der Leyen, you will see that, well, she was forced to, let's say, take note of a number of powerful messages sent in on the occasion of the election campaign. You know that she was parachuted in Brussels literally overnight, arrived without a real program because she was not running for that position. What did she do? She toured all party groups in the European Parliament, heard a lot, and if you look at her program, the least you can say is that there is a remarkable symmetry, not with pledges that were made because she didn't run, but with themes that emerged quite forcefully from the electoral campaign. First of all, of course, the idea of the Green Deal, which was really one of the strong themes, or the necessity to tackle the climate change problem was really one of the strong themes of the campaign, and we witnessed on the occasion of the election a strong emergence of green parties in a large number of countries. So it's interesting to know that even, let's say, a character who did not run was forced to listen to what the voters had to say, and to integrate her analysis of the election's outcome in her commission's program. So I think the jury is still out to see what the future of the Spitzenkandidaten is. I know that it's been declared dead by a number of people after the appointment of President von der Leyen. I think it's premature.
Professor Dehousse, I do apologize, but perhaps we should very soon go on to the discussion with Professor Egan and then the audience. So if you have a final word, and then I can give the floor to Professor Egan.
Absolutely. No, but I was really at the end of what I wanted to say, namely, we have a big tension between two now historical trends, the reinforcement of supranational bodies violenced by national governments on the one hand, the emergence of a strong popular resistance to this trend. The way forward on paper would be to make European institutions, at least those that claim a political legitimacy, more responsive. Question, but I stop at the question. I won't try to answer it. What do we do with those control missions that have been entrusted in the political executives? I mean, if the commission is to control the member states, can this be done by a political commission? Can competition policy conducted by a political commission? Can the surveillance of member states' fiscal policy be conducted by a political commission? That's not a simple question, but let's leave room for discussion.
Thank you so much. Michelle Egan, the floor is yours for some questions and comments. I would like to also remind our audience that you can absolutely send your questions to me via the webinar chat box, and we will turn to them at the end of our webinar. You have the floor. We can't hear you.
Thank you. That was a whole host of issues to digest and think about. I'm going to start off with a big question. What the role of EU law is and ought to be? And to me, that's what the book is about. And I'm delighted to do this book launch in Europe. I participated in the launch in DC at George Washington, and the book is about law in context, and it's going to appeal to politics and law, both audiences, because it fits on economic governance, human security, rule of law, and internal security. And you can actually read the chapters separately, which is really nice as well. And the title, as I've told Francesca before, EU Law in Populist Times, feels like a little bit of a misnomer, because the book is about something about populism a little bit, but it's also about crises. And I want to highlight what I think are some of the big themes in the book, and then a bunch of questions and comments, or just food for thought. The first theme, I think, is the reconstituting of sovereignty. Its incursion into these core state powers, migration, security, economic governance, and they've been heightened during the crises. And you see that with the Eurozone, you see that of border controls and agencies, and it sort of builds on decades of market making, of market regulating. To me, that's the spillover. The second theme, I think, is rule setting and enforcement. And here, I think this is about trade-offs. This is about challenges. This is about incomplete contracts. This is about non-compliance. and shifts in the forms of rule that we have seen in these different policy areas. And what we've also seen is it's become more coercive and less voluntaristic. And if we go back and think of all that debate on the open method of coordination and the soft law, we seem to have moved away in these policy areas with increased conditionality. And so what we see is a strengthening, whether it's, you know, successful or not in the area of rule of law or in fiscal oversight. So I think that rule setting and enforcement is a second theme. I think the third theme that comes up, interestingly enough, in this book is the role of differentiated integration and the asymmetric effects. Sense in terms of the application of these laws and policies that it creates insiders and outsiders, immigrants and non-immigrants, members of the Eurozone or not. And so from that point of view, you know, what is sort of the impact of this deep coordination, legislative and regulatory harmonization, and sort of growth of state capacity? And it can be sort of both positive and negative in terms of the recipients. Like when we talk about winners and losers of globalization, we're going to have winners and losers as well in this increasing and reconstituting of sovereignty and the expansion into these new areas. So what I think, picking up on the last set of comments, is this intrusion raises populist heckle. That, I think, is sort of the message of the book. And these huge areas are subject to jurisdiction, increased jurisdiction, constitutional reasoning, and administrative discretion. So my question is, what is the causal connection with these populist challenges in Europe? And I think what the authors are trying to do in some of these chapters is talk about the trade-offs. And the trade-offs in these different chapters are about the politics of risk mitigation and risk management. And here, that's in economic governance, whether it's in rule of law, whether it's in internal security. And you see those sort of trade-offs in terms of preventive justice. That is curtailing privacy rights because of the encroachment into security. You see it in terms of trade-off, in terms of fiscal oversight. It has differential effects between North and South debtor creditor nations. And then you also see another trade-off between technocracy, delegation, and administration that Francesca talked about versus democracy and the circumvention of democratic practices. And so I think that these concepts that Francesca talked about, the rule of law, the rights, the democratic core, are very important values that need to be protected. But populism seems to have been a response to the effects of some of these trade-offs. And so I found that particularly interesting. And so here I wanted to sort of think about the bigger picture. And I was sort of, the question for me is, with the centrality of these legal principles and objectives and values, whose legal principles and values? And I was very much struck by, in reading all of the books sort of in its totality, is that it seems like the whole legal framework of the EU almost, I don't want to say has been transformed or changed, but that's the impression you get. I was really struck by the integration through law model, that model seemed to be the old model. And here it was, the first part of it was, as Francesca talked about, it was about legal complexity, international law, supranational law, national law, and a variation of these. So we had this legal complexity. The second thing we had was legal uniformity in the integration through law model, which was sort of the single market, but also now the discussion, if you like, on the level playing field in Brexit. And then the third issue was legal dependency. And here national courts were really important as well for the enforcement of European law. And so then it got me thinking about, with these new areas, what are the effects of the constitutional fundamentals across member states in these new areas? how is populism manifested towards the legal architecture in Europe? So here I'm saying that, you know, if the traditional model, if you like, was legal complexity, legal uniformity, and legal dependency, the new model coming out of these chapters seems to be legal circumvention. And here a lot of these policy areas in economic governance, in asylum, and other areas, they started out outside the treaty framework, outside of case law and jurisdiction of those areas. So legal circumvention seems to be sort of part of the framework. The second part of the new framework seems to be legal resistance. Now, I know historians always talk about resistance to EU law, but here we've got some really deliberate EU legal resistance, whether it's the rule of law challenges or the Polish logging case in forests. There's plenty of case law examples in the book of this, you know, resistance to European law. And then the third thing that perhaps is different now than it was under the sort of the way we used to think about law is the role of differentiated integration. And here, if you don't have uniformity, you have opt-outs. We used to see that as a political solution, you know, a political solution to allow spillover, to use your concept. We used to see that as a solution for spillover, but it also has a legal impact. And it has a legal impact in the sense of insiders and outsiders. It has a legal impact about whether you're included in certain discussions or not in the Eurozone. So it does have that differentiated integration, also makes some states feel included or excluded. So a few thoughts and considerations about picking up on what essentially is, how do we respond to this crisis? How the EU has responded with the transfer of authority, and sort of how we deal with this ability to deliver, which was sort of the final comments of Professor Dehousse. And here my comments are the following. You know, what really is the causal connection between this internal policy expansion and populism? That's very, very important. You know, what is the causal connection? And the first comment and observation I will make is that when we're reconstituting this sovereignty, to use Nicolas Jabko's concept, when we're reconstituting this sovereignty, it's an upward authority migration to the European level. But there's also been a corresponding downward authority migration and a downward pressure, whether it's devolution, secession, decentralization. And so we should ask ourselves, what is the role of law or courts in that process, both as democratizing but also as curtailing? And so that's, I think, important. It's not just one level of reconstituting authority. What we've been seeing for decades is also a reconstitution of authority downwards as well. The second comment is, given the transformation in these policy areas of internal security, economic governance, and so forth, it's obviously changing the legal norms, reconstituting sovereignty. Is populism against the process, or is populism against the outcome? And that's something for us to think about, because that may impact then what Professor Dehousse says about what instruments should we be using are viable to address these crises. And then perhaps the last two comments I will raise is the centrality of legal principles values in terms of whose legal principles and values. And there's an emphasis on the book on territoriality, an emphasis on the effect and response of member states. And we heard that very strongly with the mention of Alan Millwood, but the impact of this expansion of regulatory capacity, expansion of legal complexity, is also sort of on the access to justice. What about the impact of this reconstitution and response to crises on different groups, by gender, by race, by class, by migrants. The focus of the book is territoriality. I think the next book should be on groups and so forth. And then finally, the last couple of questions to leave it to the audience to open up. How much has this over-constitutionalization of law, to use Grimm's phrase, contributed, affected the response to the crisis? And is this sort of, what I'm saying here is, has the law's externalities created backlash? And then finally, in this current COVID environment, and I heard this sort of in the comments, will those old regulatory laws of the single market resurface? If we're moving to a Green Deal, to digital, to an economic recovery, to investment rules, is it possible that, we also need to consider and think about looking back to not just dismissing sort of the old rules on the old regulatory model of the single market, because after all, some of the issues of medical devices and so forth relate to, in public health, single market rules, because we don't have competence in public health. And finally, I was really struck. I'm sitting in Washington, D.C., and I want to make the final point here about being in D.C. One of the striking observations about this book was that, as somebody who's interested in federalism in the United States, a lot of the deviation of states in this book was punitive or negative, that they were forced to have conditionality for the Eurozone bailouts. They were forced to, or the austerity union, as it was referred to in the book, or they're deviating from rule of law and may or may not have structural funds taken from them, as Dan Kellerman points out. And I'm really struck by, in the context of the crisis in the United States right now, that it's very much a punitive view towards states, whereas in the United States, the response to the crisis has actually been, to use the old political science literature, states have been the laboratories of democracy. States have been the innovators. Thank you.
Thank you, Michelle, for raising so many interesting points and questions. I think we can give the floor back to Francesca Bignami for some initial comments, and then I know that Professor Dehousse has to leave us rather soon, so perhaps we can go to him and then Professor Mitsilegas.
Okay. Thank you so much for those presentations, for the contributors to the book, for being willing to be here and discuss the current context and their contributions, and to Michelle Egan for giving me those very wide-ranging and very incisive comments. There's so much to talk about. It's hard to know where to begin. But it's, I think that I want to, because I'm also sitting in Washington, so I feel where you are essentially here, and I don't know if it's, and what's interesting, I think, about your final comment here and the comparative federalism point, and it's become so clear with COVID that there's a lot to be done on the comparative federalism point. But it's very clear, and that's also been clear in the comments of Professor Dehousse, that the starting points are just so different, right? So, American federalism begins in the late 19th century, and therefore, the robustness of those state regulatory frameworks is actually not the same as the robustness of the member state European regulatory frameworks. And so, American federalism comes about with the administrative state. So it's contemporaneous. And so the power of Washington is contemporaneous with the power of the administrative state. But in the European context, the power of Europe comes somewhat afterwards. And so I wouldn't say that Europe is punitive and America is experimentalist. It's just that, the punitive quality somehow has to compensate for the vast decentralization of the European continent, whereas the experimentalist quality has to compensate for the incredible centralizing tendencies of Congress and the federal government. So I guess I'd like to, I think it's a very interesting observation, but I do think that it reflects very much the different political realities of the two places. And I'll leave it there because I'm very interested in what the audience has to say.
Professor Dehousse, would you like to comment on these points? We can't hear you. I think your microphone is muted.
Correct. Apologies. 2 remarks only. To echo what was just said by Francesca on the punitive aspect of Europe, I think this owes a lot, as does over-constitutionalization, which is part of the same toolkit, to well, what I tried to describe in my initial remarks, namely integration is not a love affair. It's a marriage, if you want, between states that do not necessarily trust one another, hence the necessity to keep the other guys under control and make sure that infractions are duly punished, which does not always happen easily. And that's indeed one of the difficult aspects of the European construction. Now, populism added onto that makes it even more bizarre. I mean, I remember when 2 years ago, Italy had a populist government with a strongly, let's say, Eurosceptic agenda. It was a strange mixture of critique of Brussels bashing, basically, accompanied by pledges in favor of more European action and more European support. And the two are, of course, impossible to reconcile. But if you look at, just to take one example, Matteo Salvini's discussion of the role of Europe in migration policy, he was not complaining against the EU doing too much. He was complaining against the EU not doing enough, which is paradoxical, of course, for a populist, but it shows that there is not yet a strong, let's say, body of doctrinal principles in those parties. There is a lot of opportunistic reaction to what goes on, and you may at the same time tell Brussels to leave you alone, but that they should help you more, which is one of the interesting paradoxes of populist movements in Europe. So a lot more to happen, I'm sure, before this stabilizes. And I'll stop here. Thank you.
Thank you. Thank you so much. Professor Mitsilegas, you may go ahead.
I'm conscious of time, and it's good to hear the audience's questions as well. But just a brief comment, very rich comments by Professor Egan, really fantastic comments. And the key question indeed is whose legal principles and values. And I think this question is hugely contested currently also in litigation in the Court of Justice and in national constitutional courts. And I just want to mention 2 examples of contestation, and it's interesting to see which actors are actually contesting, because it's not always the same. So first of all, in the Court of Justice currently, in the last year, we have had cases both in the field of data, data retention, intelligence, and so on, and in the field of migration, where states argue they pull off the card of the national security exception. So they're saying that this shouldn't be under EU law at all, that we should have total sovereignty, although these are EU areas of EU competence. So whose law, whose value is there, and what is applicable, and to what extent does EU law apply and European values apply? On the other hand, we see national constitutional courts, and a lot has been written recently about the German constitutional court in the context of economic policy, but also in the field that I'm following more closely. A few years ago, there was another case concerning a European arrest warrant, where the German constitutional court again issued the constitutional identity concerns, and this has led indirectly to indirect judicial dialogue with the Court of Justice about human rights guarantees in the European arrest warrant. But again, you have a different set of actors, which is not a government and which is not an argument coming from a security populism, if you like, or populism around the distribution of migration flows, but it is a human rights concern coming again from the national constitutional court. And again, this debate about whose values, whose law is key. And there, if you go to the root of interpretive pluralism, for example, it's interesting to see the extent to which EU law can also be seen as a process of co-creation, if you like, between different actors, where the Court of Justice doesn't necessarily have the monopoly, but it has really to interact with non-EU actors in developing, if you like, the values and the law in order to retain credibility.
Thank you so much for those additional remarks. I think we can. We have a couple of questions from the audience, which perhaps will give us the opportunity to develop a little bit some of our discussion. First of all, we have one from Professor Collier-Raube from the University of Leuven, who asks, let us try to think about the next critical steps of European integration. Are the upcoming European Council negotiations on the Recovery Fund decision an expression of a new way of EU lawmaking? Will the Recovery Fund be a typical example of EU law in times of European populism, or is it instead following old patterns of intergovernmentalism? And then we have a question from Nikolai Surubaro, who asks, following up on the punitive aspects of the EU, which was mentioned, do you think that suspending EU structural funds will manage to improve the rule of law situation in Eastern Europe? Perhaps we can start with the points. We are, of course, as you know, already running a little bit over time. So let's start with this, and then we see. Francesca, would you like to start?
So I'll do the second question. Maybe I'll give the first one to Professor Dehousse, since he has been following the economic policy front if he has time. But I'll take the second question first, the structural funds. And I actually think it's a good opportunity to include conditionality, to be honest, for rule of law backsliding, and not necessarily the most stringent form of conditionality on different kinds of metrics of backsliding, but simply signing on to the European Public Prosecutor's Office regulation. I think that really could improve the governance structure of the entire EU. I think that it's especially critical now that there's so much money that's being planned for the budget. And so if there was ever a concern about fraud, it's certainly much more significant now that the budget will be, seems like almost double. So I think it is a good time to do that, and I think there are good arguments for it. And again, I don't think it's punitive isn't really the way to put it. It's really it's a reflection of the immense variety that there is in the EU, which is very different from the US, where we have a federal court system. And so it's a one tool that we have that exists in the EU for dealing with that variety in constitutional fundamentals and the backsliding. And I'll leave the first question to Professor Dehousse if you have thoughts about what's happening on the recovery package negotiations.
Well, I'm not privy to that conversation, needless to say, but maybe something can be said about, let's say, the comparison between Europe's response to the previous crisis, the economic and financial crises, because there were several actually, and its response to the current, the COVID crisis. and here there is a remarkable difference, which suggests that there has been a learning curve. The first, let's say, the most remarkable aspect is that the European response has been quicker to come this time. I mean, it's fair to say that the first steps of Europe at large, that is to say, the member states and the EU, in the first weeks of the pandemic were anything but glorious. Lack of coordination, a kind of compulsive reflex of closing of national borders and so on and so forth. But in a few weeks, basically, we had the elements of a European response with the package put forward again by the ECB. We now have well, a further element of response in the suspension of the stability and pact, the reassurance program of the Commission, now the recovery fund, all this within a few months, whereas in the previous crisis, it had taken years for the EU to painfully articulate a response which, well, I mean, as was said earlier, was often a punitive response. So something has changed, and it seems to me, but the game is not over, it seems to me that in the present context, we see, let's say, supranational actors playing a more central role yet than was the case in the previous crisis. I mean, the ECB reacted, and apparently it's not been deterred by the, let's say, artillery shots that came from the German Constitutional Court, from putting together a very powerful response to the COVID crisis. The Commission, as I said, was pushed towards the center stage by the fact that member states needed a European guarantee rather than, in order not to have to support each other's debts and so on and so forth. So I see in this case signs that suggest that we may have at the end of the process elements of a strong or rather strong supranational elements in the European response. Now, it would be wrong to say that this is because let's say supranational actors or leaders have gained more clout. It is so also because governments themselves know that this centrality of supranational actors is necessary for the stability of the European system. I mean, without the Franco-German initiative, where would the Commission be? Question mark. And it's a counterfactual, so I can't answer it.
Thank you so much. And perhaps I can address the final question to Professor Mitsilegas, because I noticed you referred to kind of preventative lawmaking, and I found that an interesting idea, and or rather concept to reflect on. And how do we, especially in the context of crisis such as COVID-19, how do we kind of draw the line between preparedness and the need to react to these crises and the undue violation of liberties and so on, and indeed, on the other hand, of course, prevent populism from gaining support by securitizing these kinds of issues?
I think it's a difficult question, and especially how to manage currently, like the current COVID situation, and how can you, if we can call it an exit, how can you exit? I think, if anything, I mean, it's easy to be very gloomy about it and to say, that's the end of the world. Everything is about prevention, and we are all going to be tracked on a constant basis. But what reality has shown actually is that this is really much more complex. And if anything, I think the current crisis has really shown the need for a solid framework. I think one of the big things with prevention and especially with the crisis mentality, is that we have these responses that emerge without justification and without reasoning. They emerge very quickly, and then we all have to follow them. But I think here, the current situation, because it involves, it is an existential crisis, really. I think it has really cast light also of the inadequacies of these justifications and the inefficiency of the preventive schemes that are being proposed. So, and I think now we see the need to justify in order to gain, if you like, citizens' trust. And I think currently this trust is lacking. So, so this lack of trust, if you like, can also be a safeguard and can also make us be more critical about preventive responses in other instances, for example. So I think we should not forget that. And I think with COVID, what has changed is that it's this realization that this can affect all of us and everybody. I mean, it's easy with the responses, for example, to migrants or, or to perceived terrorists, to say that it's never going to be me. It's always going to be someone else who is under surveillance. But I think COVID-19 has really shown us that it is really all of us. And now perhaps, this is an opportunity to realize and to really be very reflective about our place in a democratic society.
Apologies. Thank you so much. And I know that Professor Dehousse has to leave us, but if the rest of our panel can still stay with us for just a few minutes, I have some last minute questions from the audience. And thank you, Professor Dehousse, for joining us, which perhaps we can address quickly and then bring our discussion to a close. So we have, first of all, Fernanda Nicola, who asks, referring to the point raised by Michelle in terms of the downward pressure created by EU law integration, which seems to be a call for the populist agenda, unless EU law becomes more embedded in European societies. Can the European Court of Justice really take this into consideration in terms of the differentiations that are raised without falling into the populist trap of national traditions? And finally, we have a question from Lucas Huttman, who instead begins by saying that he agrees with the analysis proposed in the book and during this panel. However, he wonders, how do we achieve that fundamental rights concerns and democratic decision making are truly at the center of EU policy making, and how do we convince or even indeed oblige member states to be more concerned with these matters when claiming sovereignty or national identity? And I suppose these two questions kind of point to similar questions that we can address in this conclusion. Francesca, perhaps you would like to start.
Well, this is a book of law, not politics, and I'm very conscious of the fact that I'm a legal scholar. So convincing, anyone outside of the four corners of the academy is a little hard. But I think I'll. So I think that we can meld the two questions. I know the first one was addressed specifically to Professor Egan, but I do think that there is something to be said for making the point that too populist and governmental forces in member states and policymakers who are responsible for the evolution of European integration, that there's a geopolitical necessity that we are going through right now, and that is that the EU is very fragile at this moment, and it's under attack from many different sources geopolitically, and I think the world is a better place with it than without it. And unfortunately, the current juncture is one where that's actually a real possibility without it. I mean, and going back to my experience in the European Commission when I was a stagiaire, that was inconceivable back in 1992. But now it's conceivable. And so the first point to make is that it's, this is, there's a certain amount of necessity here. And as part of making this, what I think is a necessity true, is making it more responsive to fundamental rights. And the EU's vision of the liberal democratic order, it won the Peace Prize many years ago for a reason. And it is a very central vision of the liberal democratic order, and that makes it stronger, not weaker. The same is for democracy, and so for what Professor Dehousse was saying earlier on democracy and giving European citizens more of a say through a modified or the Spitzenkandidaten process. This kind of debate makes it stronger, and it's important for the EU to be strong. So I think that there is, we can meld the political question with the question about how it is that we incorporate rights and democracy, because the two really are extraordinarily connected. They're very, very linked.
Thank you for that. Michelle, perhaps, would you like to come in?
Sure. Thank you. Tough questions. I suppose that the couple of comments that I was sort of emphasizing is that if you reconstitute sovereignty and you encroach on competences, you're not just encroaching on national competences, you're also encroaching on sub-federal competences. And that, that means you're shaping both public and private goods through potentially legal decision-making or the policy encroachment, and that can have unintended consequences. And my second point was that we're treating the member state as if it's a unitary actor, which goes back to the earlier point. And, if we look at policies, and I'm a political scientist, and I think about Ted Lowy, who talks about regulatory, distributive, and redistributive policies. Different policies have different outcomes and impact different groups differently. So it's the unintended consequences that I'm thinking about. The fact that we're treating the member state as a unitary actor, and that, one also remembers that if we enhance somebody's democracy and rights, I think that was exactly the cybersecurity, when we're trying to enhance people's, say, safety and security, we're on the other hand undermining somebody else's particular rights. So that goes back to my concept of trade-offs. And so that was sort of my broader point, in terms of trade-offs. When you include somebody, you're excluding somebody else just by the nature of potentially either the political or the legal decision.
Thank you. Professor Mitsilegas, some concluding thoughts, and then we will bring this webinar to a close.
Thank you. Just one point, I think, which is I would emphasize the the need, I think, to communicate, to deliberate, if you like, to reconnect, to go back to your project. And I think that you need to, I think from the point of view of the European Union currently, I think you need to have more channels of communication on the one hand with the citizen, and the citizen is not necessarily a national of any member state, it is at the EU polity, and this should not only be at the level of Spitzenkandidaten. I think there must be avenues of democratic deliberation in order really for the big issues to be debated at a regular basis. We need to think also from a more legalistic, if we think that law brings solutions, more legalistic way, perhaps of further avenues to the Court of Justice, I think, because the standing rules are very, very limited currently. So, and on the other hand, I think there needs to be an engagement with, to follow up on the point, with various actors within states, because exactly states are not unitary actors, and I think that there needs to be really an engagement with different actors. I mean, we see it already at the level of more enhanced, if you like, judicial dialogue between national courts, which is encouraged by the Court of Justice in order to enhance mutual trust in the area of criminal justice, for example, because otherwise the system would collapse. So, the Court of Justice is the maturity to say that we cannot really have a system where there is no communication, where whatever we say in Luxembourg is applicable if our national actors really will not take it on board. So I think we need to be more open, and we need to have ongoing avenues of dialogue and communication if you want to avoid the rupture.
Thank you, Professor Mitsilegas, and thank you to our wonderful panel. And thank you, of course, to our audience for sticking with us. We are a little bit over time, but I think the discussion was indeed very, very interesting. We are planning our final conference on the 3rd of July, a day-long online event which will replace our physical event that we normally organize in Brussels. So please stay tuned, as we will be soon sharing details on this. So we very much hope you will join us there. And from all of us, it's thank you and goodbye.
Thank you.
Thank you.